I pled guilty to a fictitious plea for Category D perjury, which I did not commit perjury. The state vacated and overturned.
Good morning, everyone. We are on the record on the Cristos matter, case number D20C. May I have appearances, please?
Good morning, Your Honor. Abira Grigsby, bar number 10308 of Cranford Plain, is present.
Thank you and good morning. Good morning, sir.
Good morning, Dorian Cristos.
Thank you and good morning.
Good morning.
Let me go ahead and have both parties stand and raise their right hand.
Do you and each of you solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated. This is the time set for evidentiary hearing going forward. First and foremost, thank you to all the officers who are here. We're transporting Mr. Cristos here. And thank you, our Nevada judges, for your service to the community. Are we ready to proceed for evidentiary hearing?
Yes, Your Honor.
Okay, excellent. I do have, I have some exhibits here, I believe. When I do my evidentiary hearings, I believe, Ms. Grigsby, you've appeared in my courtroom before. You're welcome to provide opening statements if you'd like. It's not necessary. I'm fully briefed. I've read the file all the way back to prior orders. I am prepared to go forward in this matter. I like to focus the evidentiary hearing on the evidence. I don't do closing arguments in my courtroom. You can submit your closing briefs with your proposed findings of fact, conclusions of law. That way it allows you to go back and look at the record, look at the evidence that was presented, and make your arguments based on the evidence presented. My focus today is on the evidence, so I will be ensuring that we have equal time allocated. We do have 6 hours today, 3 hours for each side. I'm not your timekeeper, but I will be ensuring that we have equal time allocated. Anytime that you stand, anytime that you speak, anytime you cross-examine, anytime you so much as make a noise or make any arguments, it will be allocated to your time. So please use your time accordingly and sparingly. Okay? I have received, pursuant to my evidentiary hearing management order, which was entered on September 30, 2025, your memorandums, your pretrial memorandums were due on July 2nd, 2026. I believe I sometimes give extensions of time to the litigants, especially if I have litigants that are self-represented. I do give extensions to submit your pretrial memorandums, but that extension is only up until the calendar call. I did have both parties present for the calendar call, and I reminded the parties that if they had not submitted their pretrial memorandum, it will be due no later than 5 p.m. on the day of calendar call. Calendar call was on July 9th. I do note that upon review of the record, I received only one pretrial memorandum, and that is from the plaintiff in this matter. It was timely filed on July 28th, that's not timely filed. So did either party file a timely pretrial memorandum in this case?
I was not given any notice or service
Stand when you speak
document.
unless you have a medical condition.
Excuse me, sorry. I wasn't given any notice regarding any of the due dates. I wasn't able to e-file any exhibits or subpoena witnesses. I have zero opportunity to do that at the prison. They don't have e-file services for state cases, only federal cases. I was attempting to argue good cause at the July 9th hearing regarding my inability to follow procedures based on the location that I was at and their services available. It's impossible for me to subpoena witnesses, submit exhibits, provide a pretrial memorandum. There's a lot of information that's in the Odyssey that I would like to bring up from other specific dates. I don't know if exhibits can be brought up from there, specifically November 7th last year.
Well, I will be taking judicial notice of the file of the Odyssey. So any orders of the court, I will take judicial notice of that. Any orders of the court are still in order, are still in place, or at least as far as history is concerned, if I need it for procedural history purposes. I do recall at the calendar call on July 9, you did argue and request for a continuance. I did not find good cause to continue. I did find that both parties were served with my evidentiary hearing management order. It's your responsibility to ensure that you comply with the rules of the court. That includes litigants who are pro per and litigants who are incarcerated. I've had incarcerated litigants in my courtroom and they've been able to comply. So at this point, I will be following through with my evidentiary hearing management order.
I didn't receive an evidentiary hearing management order at any point in the since the inception of you becoming our judge. I did get a notice from Clark County regarding the September 30th date. And I remember you saying in court we had the July 9th and July 31st, but I didn't get, I wasn't electronically served or physically served any
Are you
papers.
signed up for electronic service, sir? Because you are responsible for ensuring that you're signed up for electronic service.
There's no electronic service available at the prison. They serve you documents that officers will sign off on as served, but I didn't receive anything. So I have
Okay.
really no understanding of how to procedurally follow the rules that are set forth because of the paperwork issues.
All right, well, I'm gonna allow you to present your testimony today. Your testimony is the most important. You also will have the right to cross-examine any of the plaintiff's witnesses if they have any witnesses today. I haven't heard from them yet, so if they have any witnesses, you do have a right to cross-examine the plaintiff as well.
I didn't get
Today's trial is gonna be focused on custody, as I mentioned at the July 9 hearing. I will not be continuing this matter. Custodial matters take precedence on the court's calendar. And if I continue this, it would be out till probably March or April of next year.
I would be
don't
fine
find
with
it
that
possible.
if we could have a I was hoping that we could privately discuss a settlement to alleviate this entire matter. I think they would be very happy with what I would have to offer.
Okay,
I'm concerned about the publicity of this case.
Okay.
Several media outlets have reached out to me. I've kept a zip lip. I don't want to expose our children or their
I
mother
understand.
or the backstory of everything that's happened the past
Okay, sir. Well, let me
14
go ahead
years
and hear from them
regarding.
and see if they'd like to do it. I'm more than happy to brief, to trail this matter. I'll go off the record, I'll step outside of the courtroom, and I'll give you guys my courtroom so that you guys can have a settlement conversation. But in order to do that, I have to have an agreement on the other side, okay?
Understood.
So go ahead and
Okay.
have a seat, let me hear from the other side.
Okay.
Thank you, sir. Ms. Grigsby,
We're ready to proceed. We don't believe any type of settlement is feasible in this case.
would you like to at least hear what he has to say? I'm happy to step out if you want to just hear what he has to say.
No, Judge, he has, I've been on this case, I want to say, for years, and every settlement offer that has come through has been so out there that it's just, it has never been feasible to actually follow through with the settlements that Mr. Cristos has proposed.
Okay, and I understand that. I recognize you've been on this case longer than I have, but I always would like the opportunity to encourage settlement, especially as we are now in trial and we do have, the benefit of having our Nevada judges here, which I very much appreciate. But I recognize that can put tremendous pressure on the parties sometimes. So in the interest of just giving Mr. Cristos an opportunity, I'm gonna step out for just 1 minute. I'll allow him to just let you know, Mr. Cristos, I'm gonna give 1 minute for you to just let Ms. Abira Grigsby know what your offer is, and if she doesn't want to, she doesn't have to proceed, okay? But I'm gonna give you that benefit of the doubt, okay? We'll go
Okay.
off the record. Our Nevada judges, I'll ask if you can please respectfully also go off the record, and if you can please step out of the room when I step out. When I come back in, we'll let you know so you can come back in, okay? All right, sir, I'll give you just a minute, okay? Talk to
Okay.
Ms. Grigsby. All right, thank you. We're back on the record on Talix and Cristos, case number D20607245C. This is the time set for evidentiary hearing. The court did take a brief recess for 45 minutes, actually, in order to give the parties an opportunity to discuss negotiations. Counsel, has there been any resolution?
No, Your Honor.
No resolution?
No.
Okay, well, I thank you guys for engaging in good faith settlement negotiations. At this point, we're going to go forward. We will have 45 minutes less of time, but at this point, we'll go ahead and go forward. I'll allocate the time accordingly. Do you have opening statements, counsel?
No, Judge, I'll wait.
You ready to proceed? Parties both have been sworn in already. So, Mr. Cristos, I have reviewed the file. Would you like to make an opening statement? If you do, it will be coming out of your time, okay?
Okay.
Go ahead. If I'm looking at my clock, it's only because I'm keeping track of your time, okay, sir?
Can I have the exhibit list that's on my desk to review? Is that
Yeah,
fine?
that's for
Sure.
sure.
Absolutely.
That's fine.
Okay. Please. Go ahead, sir.
I didn't have a chance to look at this. So I was under the impression that all of the findings regarding what led to the temporary sole physical, sole legal custody were covered by issue preclusion, which there are all instances from the past that have already been litigated on, and the judges from the past, Judge Henderson specifically, dealt with every domestic violence incident, finding of domestic violence, and he decided that we had primary physical joint legal after all of the instances combined. There haven't been any new DV incidents since then, and on September 30th, was awarded temporary sole physical, sole legal with potentially a permanent sole physical, sole legal order based on the domestic violence findings that were made on September 30th. She said DV had occurred in front of the children in the past, and you granted her temporary sole physical, sole legal based on that. I'm sure there are other factors in there. In my arrest, I'm incarcerated. My incarceration was overturned. They had me plead to a lesser crime that's unrelated to Judge McConnell. There is no, victim Judge McConnell in this case anymore. The parole board, the state, the district attorney's office said that I was illegally prosecuted. My Sixth Amendment right to a fair trial was violated. The entire case was thrown out, and they had me plead to a lesser charge that would have me released immediately. And I'm waiting for Carson City to process that paperwork to release me. Along with that case, because of that case, there was a TPO stay out of trouble clause, not physical domestic violence incident or even a communication domestic violence incident. And that TPO stay out of trouble clause was what triggered the T case from last year to be extended. Now that the case that triggered the T case has been thrown out, effectively overturned, I believe when I go in front of the TPO judge that they would also remove the T case that was associated with that stay out of trouble. But my primary concern is that findings that are effectively barred by issue preclusion that have already been litigated and ruled on have been used against me to issue the current temporary sole physical, sole legal order and have me on the chopping block for potential losing custody to sole physical, sole legal. Specifically on September 30th, that DV had occurred in front of the kids, and you said you were giving her sole physical, sole legal, and attempting to protect the children psychologically because of her testimony regarding DV occurring in front of the kids. All DV that's incurred in front of the kids has been ruled on by Judge Henderson. And according to the appeals that I've read online that was done by Fred Page and the appeal in this case, the Supreme Court specified that any DV findings that have already been litigated and ruled on by a judge cannot be rehashed, they cannot be relitigated on. And today, we are here relitigating prior DV findings that are procedurally barred from being reopened. If there are findings made against me regarding a case that was overturned, that had a T case attached to it, that had no physical DV, there was a stay out of trouble that was triggered from that, then I guess that's open for discretionary rulings. But given that case was overturned and the district attorney's office, Carson City, vacated that entire case, I would think that it wouldn't have an effect. But despite all of that information, there was no physical DV that occurred in front of the kids at any point in the last 5 years. So DV occurred in front of the kids in 2019 and 2020, which is true, and it's in our initial decree. That's already been openly discussed, brought up multiple times, and the order for that DV in those incidents is primary physical, joint legal. And I don't think that it should change because of an unrelated arrest that has me incarcerated right now. I would hope that the court would possibly peer into that history and find that it did award sole physical, sole legal based off of testimony that has already been weighed and orders were made from it. So that's my opening statement, I guess, among other things.
Thank you, sir.
Yep.
All right, 39. All right, Ms. Grigsby?
Would you like to call Mr. Cristos?
Okay, so, Marshall, will we be able to bring Mr. Cristos here, or is it easier to just leave him at where he's seated?
Me?
No, we'll leave him there, okay. Mr. Cristos, you're currently on the witness stand, so I remind you, you're under oath. At this time, Ms. Grigsby is going to be asking you questions to which you have to respond. Again, wait until the question is asked before you provide your response, okay? Go ahead, Ms. Grigsby, the floor is yours.
Thank you. Mr. Cristos, what are you currently incarcerated for?
I pled guilty to a fictitious plea for Category D perjury, which I did not commit perjury. The state vacated and overturned the initial arrest after 11 months and 8 days of being.
Sir, I'm going to caution you right now. I want you to answer the question that's asked of you. She asked you, what are you incarcerated for? She didn't ask you about the history.
Okay,
So I remind you, when you're asked questions, listen to the call of the question.
okay,
Answer that question only, okay?
okay,
You will have a chance during your redirect where you can provide the explanations.
okay.
All right, so, and Ms. Grigsby, if you need, please preface your questions if you're asking yes or no. That way you can assist and guide the witness. Okay?
Okay.
Thank you. All right, so again, the question that stands is, what are you incarcerated for?
I am on June 8th this year.
So, sir, it's just what did you do? Sign a guilty plea agreement?
I signed a guilty plea for a fictitious plea on June 8th this year for perjury. A fictitious plea is a crime I did not commit.
So you signed a guilty plea agreement for a crime you did not commit, is that your testimony?
It's called a fictitious plea. They had me plead guilty to perjury, and I was never charged formally with perjury or arrested for perjury, so that's all on record, June 8th, 2026, in front of Judge Monica Trujillo, District Court.
And what is your sentence for that?
14 to 48 months, which is an 8 to 19-month sentence with the structure that they have.
So when does your sentence expire?
I should have been out in January this year, but because of Carson City error, both at the Offender Management Division.
Or, sir, let me just rephrase that. Do you know when your sentence expires?
May 15th next year.
It's May 15th of 2027?
If I do not get parole, which I am entitled to parole because I pled guilty to a non-violent crime, which is why I said I should have been out in January.
Again, so you have to listen to the call of the question.
Okay.
I'm cautioning you.
My apologies.
Is it true that you were recently denied parole?
For the wrong charge, yes. The parole board denied me based on the charge that the state overturned and
Sir, there's
vacated.
no question pending.
I'm being re-seen for it because they made an error.
So you have a parole hearing coming up?
Yes.
When is it?
It should be in October or before. I was supposed to be in June. In June, they had me
No,
scheduled.
so the question is, when is your parole hearing set for?
It's not officially set yet because of the errors that they are working on. October is when they told me it should
So
have been on calendar.
currently you have no parole hearing pending, is that correct?
No, it's not accurate. There is one pending. They just have to schedule it. They've said that they made an error and they're putting me on the calendar.
Again, sir, the answer is yes or no. Is there a parole hearing or not?
Yes, there's a parole hearing pending in October.
October, what is the date?
I'm not sure specifically. They haven't given me.
So it has not been scheduled.
I haven't been given notice of the schedule. It may have been scheduled.
Okay,
But they
but to
move
your
slowly.
knowledge, there's no date set for a parole hearing, is that correct?
No. They told me that I am automatically to be rescheduled and their earliest calendar is October. So they don't have a specific date that they've served me with yet. They told me that,
Okay.
yes, I'm on calendar for,
We can move on. So you testified that you changed your plea. What was your original plea for?
for harassment, stalking with use of internet.
Okay, and who was the victim for those?
There is no victim, they overturned the case.
No, when
It doesn't
you,
exist.
when you pled to it, who was, the victim for that crime?
Judge Regina McConnell.
And is it true that you made threats towards her?
Civil, legal, Supreme Court related,
So your answer is
Nevada
yes?
Commission of Judicial
Sir,
Discipline.
the question is, poses yes or no, did you make threats against Judge?
What kind of threats are you specifying?
Any kind of
Illegal
threats.
ones or legal ones?
Well, tell me, what's your understanding of legal threats?
Telling someone you're going to sue them in front of the Supreme Court and report them to the Nevada Commission of Judicial Discipline for violating several sanctions that they swore to uphold. It's legal to file a lawsuit, it's legal to file a complaint, it's legal to contact the Nevada Commission of Judicial Discipline. And that's what I did. And the state illegally prosecuted me for that, violated my Sixth
Isn't it true
Amendment right.
isn't it true that you pled guilty to that?
Under duress and coercion and intimidation.
Sir, the question's a yes or no question. Did you plead guilty to that charge?
Yes.
Counsel, are you moving to strike the rest of the sentence under duress coercion?
Yes, Your Honor.
Okay, so stricken. Again, Mr. Cristos, I caution you, if you keep providing this commentary, your commentary will be stricken. It's not helping your credibility if you're not listening to the rules, and it's gonna come out of your time. So please listen to the call of the question and answer that question only. I assure you, you will be given an opportunity to present your case and talk as much as you want, up to your time.
Okay, my apologies, I'm very unfamiliar with
I
this
understand. That's why
environment.
just listen to her question, okay?
Okay,
Thank you. Go ahead, counsel. So stricken.
And is it true that you filed a civil action against several judges, including Judge McConnell, Judge Henderson, and Judge Tootin at Family Court?
yes, and Judge Wilson in Justice Court. They're all part of the same complaint.
And is it true that the complaint was dismissed?
I wasn't able to appear, so
So it's
It
just
wasn't-
a yes or no question.
not
Answer
with
yes or no.
prejudice.
Is it true that you also filed a civil complaint against your prior attorney, Fred Page?
Yes,
And was that dismissed as well?
I'm not sure.
Is it true that you filed a complaint against Donna's house?
Yes,
Is it true that you filed a complaint against Shining Star?
yes,
Is it true that you filed a complaint against who is your children's grandfather?
yes,
Is it true that you filed 2 different complaints against me personally and 1 against my law office?
yes,
Is it true that you filed 2 civil complaints against,
yes,
and is it true that every complaint that I went over has been dismissed?
I'm not sure.
Judge, I would request that you take judicial notice of the following cases.
Go ahead.
A-23-877959-C.
1 second. A-23-877-959C.
Yes.
Okay.
And
What case is that, by the way?
this is, that's the civil complaint that he filed on September 18, 2023.
Thank you. So taken.
A-25-914-703-C, Cristos versus filed on March 14, 2025.
1 second. A-25-914-703C.
Yes.
Filed 3/14/25.
A-23-878-167-C, filed against me personally, Mr. Grigsby, and the Grigsby Law Group, filed on September 21st, 2023.
A-23-878-167C. Filed 9/21/2023 against Ms. Grigsby and her law firm.
A-25-914-685-C, Cristos versus me personally, just Abira Grigsby, filed on March 14, 2025.
A-25914-685C. Mr. Cristos against Ms. Grigsby personally, filed 3/14/25.
And A-25-914-689-C, Cristos versus filed on March 14, 2025.
A-25914-689C. Cristos versus Mr. filed 3/14/25.
A-25-910-506-C, Cristos versus Shining Star, filed on January 21st, 2025.
A-25910-506C. Cristos versus Shining Star, filed 1/21/25.
Yes.
Okay.
A-25-910-514-C, Cristos versus Donna's House, filed on January 21st, 2025.
A-25910-514C. Cristos versus Donna's House, filed 1/21/25.
A-25-914-998-C, Cristos versus Fred Page, filed on March 19, 2025.
A-25914-998C. Cristos versus Page, filed 3/19/25.
And A-25-921-469-C, Cristos versus, this is with Judge McConnell, Judge Henderson, Judge Tootin, Judge Wilson, D.A. Rose, and D.A. Leventhal, P.D. Leventhal, filed on June 18, 2025.
A-25921-469C. Cristos versus Judge McConnell, Judge Henderson, Judge Tootin, Judge Wilson et al., filed on 6/18/25.
Yes.
Okay. The court also took judicial notice of the cases that are just placed on the record, and that they are cases filed by the defendant in this matter as to the plaintiffs mentioned herein.
And Mr. Cristos, is it true that you filed all of these lawsuits after the results in various hearings in this case?
I mean, that's past 6 years. This case has been going on for 6 years, so no matter what I file against anyone, it's gonna be after your hearings every 3 months.
Let me be more specific. Did you file these in direct response to the orders that were filed in this case?
No, filed them against individual entities as they acted out.
Okay. And so let's go over each case. So you filed a case against on September 18, 2023. What was your basis for that?
Well, it should have been committing perjury under oath during the trial with Judge Henderson. The statute of limitations is passed for that, otherwise she'd be doing 1 to 4 years in prison. It's possible.
So, Mr. Cristos,
I'm not sure.
please just answer my question.
Okay.
What was the reason for you filing a lawsuit on September 18, 2023 against?
I believe it was for lying under oath but not specifying that perjury and criminal sanctions need to be
Okay, and
pursued.
is it true that after a motion to dismiss was filed, the case indeed was dismissed?
I'm not sure. I didn't follow up on it. I think we actually agreed to dismiss the case. Yes, I agreed with her attorney, Dutch Boyd, that we would
Okay, so-
dismiss the case so long as specific terms were met between us, and they were fulfilled. I think we had a reasonable rapport after that.
Okay.
But I did willingly dismiss that case after talking to her attorney, though.
Okay, so the second case you filed against her in March of 2025, Was that dismissed after a motion to dismiss was filed?
I can't remember.
Okay, and what were your reasons for filing that lawsuit?
Repeated contempt of court, withholding the children. I filed that 13 days after Judge McConnell put in an order on March 5th to do visits with Dr. Ponzo. She had not
Okay.
been doing those
Sir,
visits.
you answered my question. So the first two went over, we just went over. You filed those after, because of this case, is that correct?
Yes or no action?
I'm not sure. Can you repeat the question? I'm sorry.
So the two cases you filed against, they were directly in conjunction with this case. You said you filed the first one after a trial in front of Judge Henderson, and you filed the second one after a order from Judge McConnell, is that correct?
I filed
It's a
them.
yes or no question.
Sir, you need to answer the question, yes or no?
I'm not sure how to. So I see merit to both responses being true. I did not file them based on specifically the orders from this case. I filed them because of her actions, but then I also did file them based on her actions that were, I believe to be inappropriate on a personal level and as a litigant in this case that should have been following orders. So it's, I guess both answers would be true to some degree. I can't definitively,
Then you filed the civil action you filed against my office. What was that based on? The one in March of 2023. Not March, I apologize, September of 2023.
You instructing her to violate the order is why I filed.
Okay, so it was directly related to this case, is that correct?
It,
That's a yes or no question.
I mean, yes and no. It should have been a complaint to the state bar, and not a lawsuit.
Again, are you seeking to strike anything out after yes and no?
Yes, Judge.
Okay, I'll need you to make the objection so on the record, Counselor Sines.
All right, I apologize.
All right, so stricken.
The second case that you filed against me in March of 2025, what was that based on?
What I believe to be your inappropriate actions as an attorney?
In this case?
Yes.
You filed a case against, what was that based on?
This isn't a yes or no question, right? I can answer it and
No,
as openly
what,
as.
what was the underlying cause of action that you filed against?
I can't remember. Can I see the case? Do you have it? I mean, it's there in the
Well,
complaint,
let me-
right?
I'll ask you a different question. Was it directly related to this case? As testimony or any other actions that would before this court? And that's a yes or no question.
Can't remember.
Okay. And you filed a action against Shining Star. Was that directly related to their supervision of your contact with the children in this case?
No, it was related to a privacy infringement. They submitted notes to the court when they did not
So,
have.
sir, Judge, I would move to strike his answer. It's a yes or no question. Did you file the lawsuit against Shining Star in relation to their supervision of you with the children?
No,
And is it true that they were supervising your visits with the children?
yes.
And is it true that they refuse to continue to supervise your contact with the children?
No.
Okay. Now, your lawsuit against Donna's house, was that related to their supervision of your visits with the children?
No, it was related to,
Is it a yes or no question?
Yes.
Okay.
I'm not sure. Yes and no, depending, I mean, I don't, do you want me to elaborate on
No?
why I specifically filed a lawsuit against them?
No, I'm gonna ask you a different question. Is it true that Donna's house was supervising your visits with the children?
Temporarily, yes.
And is it true that they refused to continue with that service?
After I filed a lawsuit,
Sir, that judge, I would move to strike the
So
answer.
stricken. Again, the question is, what would they do?
Did they refuse to continue to supervise your visits with your children?
I refused to go back to them.
Again, the question was, did Donna's house refuse to continue supervising?
No, they did not.
Okay, thank you, sir.
Then you filed a lawsuit against Fred Page. Was that related to his representation of you in this case?
Yes.
Then you filed the lawsuit against several judges, the DA, and the public defender. I just want to focus on the 3 judges, family court judges that you listed, Judge McConnell, Judge Henderson, and Judge Cheaton. Was your lawsuit based on what happened in this case?
It was based on violations of the Nevada Judiciary Committee's
So-
code of conduct.
Is it a
Sorry,
yes or
it's a
no
yes or no question. So was that related to this case?
Yes.
I want you to turn to Exhibit 2, Plaintiff's Exhibit 2.
Did I go past it?
No, there's several emails before we get to that.
How far down am I down, so. Okay, thank you.
There's no pictures.
Yes.
This one?
Can you review this and tell me what you're looking at?
Okay, wasn't?
Can you tell me what that exhibit is?
Plead the fifth.
I'm sorry?
Plead the fifth.
I don't know what the exhibit is, so I'll make some argument, counsel, or offer paper to what exhibit 2 is, and whether or not the 5th even applies.
Judge, I'm not sure how the 5th would even apply. They're social media posts that are accessible through by anyone. Specifically, they're Mr. Cristos' social media posts.
Okay, so you're offering Mr. Cristos' social media post?
Yeah.
And, okay, so
I
Mr.
object, we don't know if this is my social media.
Okay,
or
well,
who
that's
may
why
or
it's
may
being
not
offered,
have.
that's why you need your testimony today. You're pleading the 5th, I'm gonna need you to elaborate on why you think the 5th applies. We're not here on a criminal case, and as I understand, do you have any pending criminal charges regarding regarding the proposed exhibit 2?
No.
Okay, so Your basis for pleading the fifth is, I don't see a basis for pleading the fifth then, unless you have criminal charges that are pending regarding those social media posts or that can inculpate you from those social media posts. So I'm gonna overrule the objection and order you to answer the question. Can you restate the question, counsel?
Do you recognize what these documents are?
Sir, it's a yes or no answer question. Do you recognize the documents in front of you?
Yes.
Can you tell me what they are?
It appears to be a social media account.
Okay. And whose social media account is it?
I don't know.
Let's turn to the third exhibit, the third page in there. The third page in that exhibit.
I don't know which. That?
Yes. Can you tell me specifically if that's you in those posts?
It looks like someone posted a picture of a movie star next to a picture of an old picture of me showing that we had similar hair. So there's an actor in here and there's a picture of me.
Okay. And how do you know the intent of what the post was for? You said the
Because
post
our hair-
was intended to show your hairstyles. How do you know that?
I don't, I'm just guessing, because we have identical hair.
Okay. So is it your testimony that you didn't make these, this is not your social media account?
I didn't make these posts.
But that wasn't the question, sir. I would move to strike.
So stricken.
Is-
Sir, answer the question. We let the record reflect the witnesses refused to answer the question. The question stands, this is your social media account. Sir, I remind you one more time, you're under oath. Is that your social media account?
Plead the fifth.
That's overruled. Again, I'm asking you again, do you have any criminal charges pending as a result of this social media account or exhibit 2, which I don't have in front of me?
There were criminal charges filed against me that were overturned.
Okay, so they're overturned and it's a
Well,
closed
they-
case.
they
My
can
question
still be
again,
open.
listen to the call of the question. Do you have any criminal charges pending that could inculpate you from exhibit 2? Any criminal charges currently pending?
Not that I know of.
Okay, so your pleading the fifth is overturned. Your objection's overturned, denied. Now you have to answer the question. Is this your social media, or I think essentially you're asking, is that a social media account?
Yes. And Judge, if he wants to plead the fifth, based on case law, you can take a negative influence.
Okay.
So I would request that you
Alright.
take the negative
The court will
influence.
also take a negative influence and will let the record reflect the defendant refuses to answer the question. The defendant did state he does not have any pending criminal charges. The charges that he did have been overturned in his words, but the court will also take a negative influence.
Mr. Cristos, did you, let's go with each post, did you take them out of order?
I'm not sure.
So
Like
the
what
first
order
one, okay, you know what, I'll read the post. It appears to be a survey. A question posed is, when a woman takes impregnation and a follower role to the one she allows to change her bloodstream, does she lose all autonomy to the man now that her blood is not her own? His blood is now inside of her. Does this make her own by blood? This is why females take last names. Did you make this post?
Plead the fifth.
And Judge, I would request that you take a negative influence.
So taken.
Now the next one, which is a post that states, I can fuck any sitting judge in Las Vegas straight in the ass if I identify unethical behavior. In the poker world, the judges don't out each other. They slither together as a team, not holding each other accountable by law. I am the judge of all of you. Is that a post made by you?
I'll play the fifth.
And Judge, I request that you take negative influence.
Negative influence, I'll take it.
The next post, which is the pictures that we talked about, is that a post that you made?
Which one, this one? I'll play the fifth.
And Judge, I request you take negative influence.
So take it.
May I ask how you could take a negative influence for a portrait picture? I'm just curious what's that for?
You took the fifth, and the judge gets to take a negative influence if you refuse to answer the question.
What does that mean, a negative, what does that mean, a
Well, let the
negative
record-
influence?
Sorry, I just want to make sure, I want to give you a chance to speak. I want the record to reflect that I'm giving you an opportunity to answer the questions, but instead of answering the questions, you're refusing to answer the questions and you're pleading the fifth. Is that correct, sir? I just want to make sure that I have a
For
record.
these questions specifically, yes.
Yes, okay. So every time that you say you plead the fifth, I'm going to take that to mean that you're refusing to answer the question. Is that correct, sir?
Yes.
Okay, thank you. We'll let the record reflect the defendant refuses to answer the questions noted. He's pled the fifth, and therefore the court will be taking a negative influence thereon. We may move on. And I do want to note that every time that there is this commentary, it will be coming out of the defendant's time. So go ahead, counsel.
The next one, where it says I'm coming, and there's a picture there. Do you see that?
Yes.
Did you make that post?
Play the fifth.
I would request the court to take a negative influence.
Now, are these recognized by Bates numbers? Because your guys are following, but I don't have the document admitted, so.
Oh, I apologize. It didn't come through because it's dark, but
Okay.
they are in order that they're submitted.
Okay, and these are all proposed exhibit 3?
Yes.
Okay.
I was not served with any of these exhibits to prepare for trial. Any of these emails, there's a lot to read. I'm uncertain how to proceed when I haven't been procedurally given notice of any of this.
Well, let me ask this.
Would that be cause for
Counsel,
mistrial?
Counsel, did you serve these exhibits proposed exhibits to the defendant?
Judge, they are all his own writings, so I did not believe that I had to serve him. So if we're going,
My question stands, counsel.
So, yes,
You have a
you did
duty
not.
to serve.
yes, he did not serve him with his own
Okay,
writings.
well, you're not gonna be able to admit the exhibits if you didn't serve them. That's a standard rule.
I would like to
of this
move to
court.
strike all
One
these
second,
exhibits.
do not
from the record.
interrupt me when I'm speaking.
Excuse me,
You
sorry.
made your objection, let me rule on it.
My apologies.
Counsel, there is a standard rule, and you should know this. I'm not gonna admit exhibits if they haven't been served. My evidentiary hearing management must be complied with. If you haven't complied with the EVHO, have not served the exhibits, even if it's his own, I need you to first establish that you properly served the exhibits. Now, if they're already in the file, I can take judicial notice if it's a document that he attached to one of his motions. If he attached these documents to one of his own motions, you can go ahead and point me in the record to where he filed these documents as his own motions, and I will also take judicial notice of that.
And Judge, I won't move to admit these, but I believe I can ask him general questions
You
about
sure
if he's made these posts on his social media. So
Okay.
I will not move to admit these, but I would request that I be allowed to question him on, and I'll just change the form of my question.
Okay, so noted, okay. So the exhibits are not being offered. Go ahead.
So, Mr. Cristos, did you make a social media post on June 28, 2025, stating that the only reason where it's on your social media, someone posted, the only reason people in poker are nice to you is so you don't kill them, and you responded with, greatest compliment I've ever received, fear me? Did you make that post on your social
I
media?
plead the fifth regarding every exhibit that I did not get to review prior to this trial starting.
Okay, well, the exhibits are not being offered, so again, you just have to answer the question. Listen to the call of the question. I've already ruled that the exhibits are not offered.
I
Listen
don't
to the question.
remember, I don't remember There's
Okay.
thousands of posts on dozens of different social media sites. There are dozens of imposters of me online, both on Facebook and Twitter and Instagram. People like making fun of me.
So Judge, I would
People
move
like
to
to
strike all
intensify.
the commentary. He could answer yes or no.
Okay, so stricken again, answer the question, preface the question with yes or no, answer the question with yes or no. Go ahead. You want to ask the question again?
Yes, so did you make, it's a yes or no question, did you make this post that we just went over where you responded to a person saying the only reason people in poker are nice to you?
I don't remember. I don't
Okay,
remember.
that's it. Thank you, sir.
Did you make a post on June 14, 2025 stating that Mike Prince and his wife are dead from a double murder suicide in Summerlin last year because Judge Bill Henderson, Department L, our Family Court Division didn't listen to me? Did you make that post on social
I'm not
media?
familiar with any old
Sir,
social
it's
media.
a yes or no question. Did you
I don't
make this?
remember.
Okay. So, looking at Exhibit 3, or I can just ask you questions. You can look at that, or I can just ask you the questions.
I don't know where Exhibit 3 is.
Just my quick look.
Sure.
I see there's 2 exhibits. Okay.
Is your phone?
Thank you.
Back for a second.
I hear a phone ringing.
And Judge, I would move to striking.
I didn't hear it. What did you say? I didn't hear it.
He said there's a phone ringing.
Okay. So again, the question stands, is it a yes or no question?
And so, do you recognize what that is?
I plead the fifth.
Sir, is it true that you sent me a letter on May 4th, 2026?
I plead the fifth.
Judge, that I don't,
Okay. Again, regarding the letter, what is your basis for pleading the fifth? Are you currently pending criminal charges?
They're presenting exhibits that I didn't have a chance to review or study or prepare any sort of response to.
Okay, but you're being asked a question right now. Did you send a letter to Ms. Grigsby on or about May 4, 2026? It's a yes or no answer.
Plead the fifth.
Okay. And let the record reflect the defendant refuses to answer the question regarding whether or not he sent a letter to counsel.
Sir, is it true that you've contacted my office to state that you'd be responsible for facilitating therapeutic visits between you and the children?
I don't remember. I know that
Sir,
Called
it's a yes or no question.
anytime I called your office, they hung up on me.
Sir.
Yes or no
immediately.
question, sir.
I don't remember.
Was that a move just right, counsel?
Yes, Judge.
So stricken.
True that you've, that has obtained multiple temporary protective orders against you.
Yes.
And is it true that you've been arrested for violating those orders? It's a yes or
When?
no question. have you been, well, let me ask you this. Have you been arrested on multiple times for violating the temporary protective orders or the extended protective orders that were obtained by?
2023 was the last time that happened, yes.
So 2023 was the last time, so have there been multiple times where you have been arrested for violating those orders?
Yes.
And
Prior to that,
And is it true that you pled no contest to those?
I don't remember.
Quotes for indulgence. Judge, I would request that you take judicial notice of Justice Court, case number 23-CR-067295, which is a violation of the domestic violence TPO with 5 counts.
23CR067295,
Yes.
violation of domestic violence TPO for 5 counts. I presume that's State of Nevada versus Mr. Cristos?
Yes.
Okay, so taken.
And is it true that in 2022 you were also arrested for violating the extended protective order?
Yes. 23, 22, 21.
Okay. And did you have to do any type of services for those cases?
Yes.
Okay. And what services did you have to do?
The first time I did a DV counseling through Parker Sankofa. And then the second time I need to do a triple P parenting program. And I think that was it, the second time.
Okay, well, let's go back
And
to
the third time I had a therapist, I believe.
okay, let's go back to the first time. You said you did DV counseling. How long did you do the DV counseling for?
For 26 sessions, I think.
Okay. What did you learn in those classes?
To never react inappropriately regardless of the issues that are bothering you, to always take a step back, a 10-15 minute break, before responding to anything you don't like, to even take a 24-hour break before sending anyone a message about any sort of conflict, to always be rational, reasonable, respectful, regardless of the differences of opinion or toxicity brewing between myself or anyone I come into contact with, not just parenting issues, to develop a plan for succeeding in any potential future situations where friction could present itself, and to pray, to meditate, to respect everyone regardless of who they are and how they operate in my presence, even if I don't like it, and to give everyone a fair chance. I think it's probably summarizing, if I can summarize, we did so many classes, so many different topics. Mostly, emotional control, being thorough with reflection and, putting yourself in a better position to succeed in social situations.
And is it true that after that, after going through that counseling you violated again? Because you said that's what you did the first time. So when you violated the second time, what did you have to do for that violation?
Triple P parenting, pro wanting me to do parenting classes, because I was arrested for, can I elaborate, or you want me to elaborate, right, you're asking?
No, I'm asking you, what were the requirements of the violations?
To do parenting classes, you want me to do parenting classes?
And that's all you had to do?
As far as I remember, yes, the Triple P parenting program.
And the third violation, what did you have to do for that?
Community service. And a stay out of trouble clause. The second and third, by the way, were very debatable arrests. I was following family court orders, which
So
thought
there's no
superseded.
question pending.
It's
I
like-
move to strike. And were you taken into custody on any of these violations?
briefly.
For each one or a specific one?
It's mandatory arrest for a TPO violation. So yes, briefly, each one briefly.
So your answer is that you were arrested for all three?
Yes.
When was the last time you were arrested for the TPO violation?
September 4th, 2023.
Were you arrested again for, in the same case?
I don't remember. I was remanded in court for 24 hours and released. I don't know if that counts. You mentioned I violated however many times they remanded me in court under the assumption that I violated, and they were going to sentence me to 30 days, and then the judge released me within 24 hours because she realized and said on record that she was out of her jurisdiction.
Judge, I would move to strike everything after, yes, he was arrested.
Or no, I wasn't arrested. I was only arrested once for that case, September 4th, 2023. There were no additional arrests in that case.
Isn't it true that you were remanded in June of 2025?
June 30th for the overturned case, yes.
So you're talking about some overturned case. Which case is that?
C-25-392959-1.
And what were the charges for that?
Intimidating a public officer, gross misdemeanor. Stalking, gross misdemeanor.
And when you say overturned, what do you mean by that?
The state illegally prosecuted me, violated my Sixth Amendment right.
No. Just the overturned part. What does that mean to you?
In the state's own words, it means didn't happen, not guilty, not pursuing prosecution. They wrongfully incarcerated me and imprisoned me and made me aware of that 11 months and 8 days into my incarceration before they legally prosecuted me for a fictitious plea that...
So, sir, I'm going to stop you there, and Judge, I move to strike the answer as
What was the
non-responsive.
question again, counsel?
The question was, what's his understanding of his case being overturned?
Okay, it appears that he's answering that, but if you want to hone in your question a little more, you can. But I'm not gonna strike that when he prepares his answer, but that's his understanding.
So my question is, did it go to the Supreme Court and the Supreme Court found that those charges weren't valid? Or did, what does overturned mean? Or did the judge set it aside after hearing evidence that it required a dismissal? So legally, what procedure happened for your understanding to be that it was overturned?
An attorney filed a writ of habeas corpus citing an illegal prosecution occurred. The sentencing judge granted it good cause of hearing. The district attorney that prosecuted me for the case admitted that the state made several errors, violated my Sixth Amendment right.
So
and they-
where is that? Is that somewhere?
Yes, it's case A-943879-W, and I do have, some.
The judge, I would request that you take judicial notice of that and note that that habeas petition was not granted.
Okay, the case is A943879W, is that correct?
It was granted, they
One second, sir, I'm asking a question. Is the case A943879W?
yes.
Okay, thank you. And that's the case of State versus Mr. Cristos?
That was a civil writ of habeas corpus.
Okay, thank you. The court will also take judicial notice and review the file.
And sir, are you aware that habeas petition was noticed and not granted, was resolved, not granted?
So there was a second habeas
Is
file
that
that
a yes or no question?
I don't remember.
Okay.
The document said good cause of hearing. They substituted, they overturned the initial conviction, vacated all elements, consequences, and evidence of it, and had me plead to a fictitious plea in order to get released immediately, which I'm still waiting on.
So, sir, you had quite a few things in there.
Sure.
So is it your understanding that the habeas petition was granted?
It is my understanding that the state overturned the initial
No,
conviction.
no, no. The question's yes or no. Was the habeas petition granted?
I'm not sure, because you said it wasn't, which is very confusing, because as far as I know, they
Okay, let
vacated
me,
the conviction.
I'm gonna, Judge, I move to strike.
Strike, he said, I'm not sure was the answer I have.
Yes, after everything after.
Everything else so stricken.
I believe it was
Sir,
granted.
there's no question pending.
So are you changing your answer from I'm not sure to I believe it was granted? I just need to know what your response is. I don't need to know the commentary. Was the habeas petition granted, yes or no, sir?
To my amateur understanding,
Yes or no?
I believe it was,
Okay.
but she's telling me it's not, and she's a licensed attorney, and this
Okay.
is the first time
Not a problem. I just need your answer. You believe it's not?
it makes sense that she would say it was resolved
Okay.
and not granted, because it
Okay.
was resolved.
All right,
They
that's good
didn't
enough.
actually pull the plea and put me back on trial, so there was a resolution. So I guess if that's a middle of the road, it wasn't, because I guess granting it would be, they pulled the plea entirely, which I had the option to
Okay,
do.
so I'm gonna keep your answer at I'm not sure, you believe it's not. Okay?
I was presented the opportunity for it to be granted, but they resolved it
Okay.
by substituting a different charge and overturning the
Okay,
case.
and I'll allow you to elaborate on that during your direct, okay, because you're using up her time.
Okay, sorry.
Thank you. Okay. The time is allocated to him.
Okay.
Go ahead.
And sir, is it true that the sentence for both crimes was the same? Your original crime that you pled guilty to and the crime that you changed your plea
No, they're
to?
different categories because one is violent and one is non-violent.
No, no, no. I'm just asking about the sentence, not the category. The sentence was the exact same for both cases.
No, because non-violent takes 40% off the front
So
number,
the answer is no.
60% off the
Is
back.
it yes or no? The answer is no? Okay,
It's yes and no.
okay.
They have the numbers in
We'll
the
allow you to
paperwork.
elaborate during your testimony, okay? Save all of this for your testimony. She's asking you yes or no questions. You have to save your commentary for your time, okay?
Okay.
Thank you. Next question?
So, is it true that you were ordered to do a psychological evaluation in this case?
By who?
The question is, were you ordered to do a psychological evaluation in this case, yes or no?
Yes.
And is it true that you contacted Dr. Holland's office to accomplish, to do that evaluation?
I don't remember the initial I remember Dr. Leon Villa. That was the person that was the best fit.
Okay, let me back up. Is it true that Judge Tootin in August of 2024 ordered that you do a psychological evaluation?
I believe he illegally ordered a
So,
psych
sir,
eval.
It's a yes or no question. Is there an order by Judge Tootin for you to do a psychological evaluation?
Yes.
And is it true that you contacted Dr. Holland's office to do that evaluation?
Contacted a lot of offices. I don't remember.
Okay.
I remember you gave me 3 names and none of them did.
There's no question pending, sir?
Okay.
So, going to have you look at Exhibit 1.
I would like to not address any of the exhibits that weren't presented to me before the trial.
Okay, so you're objecting, well, right now, she can ask you a question, she's not offering it for admission, but you can have to answer her questions.
And Judge, I'm gonna use it to refresh his recollection.
Okay. So you want to ask him a question first?
Well, he said he doesn't recall going to Dr. Holland's office,
Okay.
so I was going to use the email to
He doesn't
have.
recall contacting Dr. Holland to do the evaluation. Okay.
So if I can have you turn to Exhibit 1. You take a look at it, the bait stance number 10 and 11.
You said exhibit 2?
Exhibit 1, bait stamp 10 and 11, where it says ST.
ST down. Okay, I see 10 and 11.
Have you read through those?
No, I'd prefer not acknowledging any questions regarding any of the exhibits that I wasn't served prior to this trial.
Okay, again, this is currently being used to refresh your recollection if you're stating you don't remember. Contacting Dr. Holland to do the evaluation. The document was provided to you. Now you're going to answer a new question, or you're going to ask her if now he remembers?
Well, he said he refuses to look at it.
Okay, so we'll let the record reflect he refuses to answer.
So, is it true that the general counsel for Dr. Holland stated that Mr. Cristos has called and emailed this office excessively and his communication is disturbing? I have evaluated this matter and like to decline this referral for the safety of our office staff and clinicians. Do you recall getting that from Dr. Holland's general counsel?
I don't remember.
Who else did you contact to do the psychological evaluation?
Dr. Leon Villa, and she was very accepting.
Were there other people in between that you contacted?
There were several names that were given to me by you, and none of them
So,
did
sir, the
psych
question
evals.
was, did you contact other service providers to do a psychological evaluation?
Not that did psych, they didn't
Sir,
do psych
it's a
evals.
yes or no question.
One more time, sir.
Yes, I contacted, I tried to do psych
Okay, that's good
evals with
enough.
several of
So,
them.
that's fine. Move to strike everything after
So
yes.
stricken.
Were there treatment providers who refused to do the evaluation due to your conduct?
I don't remember.
Is it true that there were several evaluators that the court offered that you contacted that you did not do the evaluation through?
All of them said that they didn't do psych evals. So everyone that the court told me to contact said that they don't do court-ordered
So,
psych evals
Judge,
anymore.
I would move to strike the answer as non-responsive, except for that, yes, he contacted other providers who did not do the evaluation.
So he did admit that he contacted other providers, everything else is so stricken. Again, preface your questions. Yes or no?
And Judge, so is it true that there are several providers who refuse to work with you?
No.
Is it true that there were providers who, in writing, stated that they could not work with you due to your behaviors?
I don't remember. I only worked with Leon Villa.
Who was that, sir? You only work with-
Dr. Leon Villa, I
Okay,
contacted her and she,
Thank you, I just needed the name, thank you.
Sandra Leon Villa.
Thank you, sir.
And Dr. Wilburn and Dr.
Sir, there's no
Ponzo.
question pending.
So you're providing me with the names?
So there was Dr. Wilburn, Dr. Ponzo, and Dr. Sandra Leon Villa. Those
Thank
are
you, sir.
the three that I worked with that.
Okay, thank you, sir. Next question?
So you eventually did do an evaluation with Dr. Leon, is that correct?
I did one with Dr. Wilburn.
Okay, sir, the question, and Judge, I moved to strike.
So stricken.
The question is, did you do an evaluation with Dr. Leon?
We did a half evaluation. She didn't have time to complete it.
So is it your testimony today that she did not forward a full evaluation to this court?
Yes, it was not a full evaluation. She didn't complete the autism testing or the second half of the psych eval.
So is it your testimony that she forwarded an incomplete evaluation to this court?
Yes,
Did she make recommendations in that evaluation?
yes.
What were the recommendations that she made?
Take it to a therapist and work on it. I don't know how I could.
I'm sorry, I didn't hear what
She
you
said to
said.
take it to a therapist and to let them analyze her paperwork, her incomplete assessment.
So she put in her evaluation that she did an incomplete evaluation, is that your testimony?
She didn't put that in there, but if you call her,
So,
she'll tell you
sir,
that.
I'm asking what was actually put in writing. So what did her recommendation state?
To see a therapist, or to provide the analysis to a professional and let them decide how to interpret. So she didn't provide any specific type of counseling or guidelines or anything. She was very rushed and she didn't complete it. So I mean, when I did take it to the therapist, they said, oh, well, this is inconclusive. They said it was an inconclusive pre-diagnostic that can't be taken to heart because she didn't complete the assessment.
Okay, do you have something in writing that states that?
I wasn't able to submit a single exhibit for this case. I wasn't able to subpoena
No,
witnesses.
sir, I'm only
You're asking
asking.
to strike that?
Yes,
Okay, so stricken.
I'm asking you, is there something in writing that states that?
Somewhere in my emails, yeah.
And who provided that evaluation?
One of the therapists that I took it to.
No, I would like a name, please.
He's either Dr. Samuel Harris or Dr. Samuel Hickson, or both. And who else was the third one I spoke to? I can't remember her last name. It was
And
Dr. Samuel Harris or Dr. Samuel Hickson. One of them, if I could pull out my emails, I would show it to you. Just
And-
this
they put that in writing and stated that it was an incomplete evaluation?
yes, inconclusive
you-
pre-diagnostic.
Did you send that to my office?
I don't remember.
Did you file that with the court asking to look at that, look at that assessment?
They didn't complete the autism testing. Dr.
Question is,
No,
Wilbur
did you
did.
submit it to the court? Sir, listen to the call of the question. Question is, did you submit that to the court? Yes or
I
no?
submitted the Samuel Harris analysis.
So, sir,
I saw 3 therapists with that same report.
Listen to the call
And
of the
this was
question,
one.
sir.
so
Listen to
would
the
move to
question.
strike all.
So stricken. The question that stands is, did you submit it to the court? He still hasn't responded.
I don't remember.
Okay, thank you, sir.
I mean, I maybe. I submitted a lot to the court it was for the March 5th hearing
There's
from
no-
Judge McConnell.
Okay, so Judge, I believe the answer was, I don't remember, I would
That's
request a
correct, that's
strike.
what I have. Did you submit that to the court? I don't remember maybe.
And Judge, regarding the evaluation that was submitted to the court, I'm not sure if you can take Dr. Leon's evaluation. I didn't make it as an exhibit
If it was
because those
submitted
are
to the court?
confidential.
Yes, it was submitted as a left side file.
Yes,
I'll just need the date that it was submitted so that we can find it because it's an extensive record.
yes,
Um,
okay. I'll
I
look
did
for
look
the-
through the record for a psych eval. I did not see one. I saw one attached as one of Dad's exhibits in one of his files. So, but if you want, I'll just need you to point exactly to what it was filed.
I'll look through it during the week.
May I intervene briefly? There's a psych eval from Dr. Donna Wilburn that was done 6 months prior to Dr.
Sir, there's no question
I'm
pending.
talking
We'll
to the
move to
judge.
strike.
Sir, when it's your time to speak, I'm gonna allow you to present all of that to me, okay? You'll have your time.
I would like to motion for a mistrial because I wasn't procedurally allowed to present any exhibits, to file any exhibits, to subpoena any witnesses. There's a mountain of information I can
Okay.
present from the Odyssey.
All right, thank you, sir.
I believe my due process rights are violated through my incarceration and me not being afforded even an opportunity to argue good cause to continue the trial. I'm not procedurally prepared, nor am I technologically able to submit anything that would benefit me in this case. I'm just writing with a pen and a paper.
Okay.
I haven't served any of these documents. Is there any way we could
Okay. Well, I'm
speak about visitation and strike the trial to a new date?
No, your motion for mistrial is denied. Like I said, I'm giving you the opportunity to provide testimony, direct testimony. I'm also giving you an opportunity to provide any cross-examination. Any of her witnesses, you have the right to cross-examine them. Any of her evidence, if it comes in, you have the right to use that for your benefit. As of right now, I'm not allowing her to even present any evidence because she hasn't served you with it. So she can question you, she can ask questions, but both of you have the file at your fingertips. So you can ask me to take judicial notice of the file as well. If you filed something, or if one of the doctors, if you submitted Dr. Wilburn's psych eval, all you have to do is let me know it was submitted on this date, and I will so take judicial notice of that. So you're not without any opportunity to present your case, but at this time, your motion for mistrial is denied. We're going forward. This is not a criminal trial, this is a custody proceeding. Custody proceedings will not be continued. You've already asked for a continuance at the calendar call, and I clearly denied that. I made it very clear that you guys both have to move forward on this because I have to render a custodial decision. So your motion for mistrial is denied. That time does come out of your time though. Okay, and I do caution you, every time that you're providing commentary that's unnecessary during your examination, it is coming out of your time. Listen to the call of the question. If it's a yes or no question, you have to just provide a yes, no, or I don't know answer. I will give you a chance to give your direct examination. You can provide your testimony and provide all of your explanations at that time. Motion for mistrial is denied at this time without prejudice. 2 minutes on this side. Go ahead, counsel, you may proceed.
Thank you. Is it true that in Dr. Sandra Leon's evaluation, she stated that Dr. Wilburn's assessments were not accurate because she did not do the appropriate testing?
I don't remember.
Okay. And did you do the counseling that was recommended by Dr. Leon?
Yes.
How long did you do the counseling for?
From the beginning of January up until the June 17th hearing with Judge McConnell, all the way through my incarceration now to this day. I am continuing to do counseling.
Okay, so you said January of what year?
2025.
Okay, and who did you see in January of 2025?
Sam Hickson, Samuel Harris, and I can't remember the lady's name, but I remember that I saw 3 people to overwork the situation in hopes that the court would see that I was genuinely trying my hardest to comply and not do the bare minimum. And I wanted different opinions because they were confusing.
Sir, you've answered my question. The 3 therapists that you saw, let's talk about the first one. You said Sam Hickson, is that correct?
And Samuel Harris.
Samuel Harris. How long did you see him for?
I saw them through June 17th when we went in front of McConnell. That's when I didn't bring any notes, and Dr. Ponzo, and I saw Ponzo as well. Ponzo was therapeutic visits, but we also did traditional therapy or, check-ins. Ponzo was from March 5th to
So sir,
June
my
17th.
question's still pending, and Judge, I moved to strike. Samuel Harris.
So it's for him regarding Ponzo, the question that stands is regarding Samuel Harris.
Yes. So when did you start seeing him, and how long did you see him for?
As soon as I got the report, in the beginning of January, I saw both Harris and Hickson, and then
I'm just asking
March
about Samuel Harris.
So Samuel Harris, you saw him,
through March 5th.
Okay, so January 2025 to March 2025.
March 5th, 2025.
And how often did you see Samuel Harris?
Saw them both once a week.
Just Samuel Harris. How long did? How
Once a
often
week.
did you see him? And what did you address in your therapy with him?
Just anything in the report that he thought was relevant or irrelevant. They were mostly
So, sir, my question is, what specifically did you address with him?
custody issues. Communication, improving communication. They were more, self-improvement, therapy, issues related things. It wasn't like, one specific topic. It was very open-ended, just, essentially like a weekly meetup to discuss anything that might be bothering me or anything that I'm happy about, or, any problems that, needed solving. It's just like a very intelligent person to check in with.
And why did you stop seeing him?
Because I completed the obligations the court requested of me.
Okay. And what makes you say that you completed these requirements?
Because I was expected to do therapy up until every status check and bring the results to each status check, which I did. So we ended on March 5th because that was the status check with Judge McConnell. Judge McConnell extended therapy through therapeutic visitation with Dr. Ponzo. So I started seeing Ponzo from March 5th to June 17th. So each individual I saw based on what the court ordered.
Sir, let's back up. So you're saying that Judge McConnell ordered you to do therapy from January to March, and at that point she said you did not need therapy? Is that your testimony?
No, I continued doing therapy through June 17th. And I still do
Well,
it
you
today.
said you stopped seeing Samuel Harris because because you completed the requirement. That was your testimony.
Yes.
Then you stated that you continued to do the therapy. So I don't understand.
I was ordered to see Dr. Ponzo on March 5th, so we reverted to Ponzo. That was per your request.
So starting March or on or about
I
March
saw
5th,
Hickson
you started therapy with Mr. Ponzo?
and therapeutic visitations with him, and I continued private therapy.
So would it surprise you to learn that Mr. Ponzo stated on many occasions that he was not doing individual therapy with you? Only therapeutic visits?
We were doing therapeutic
So, sir, the question,
reunification therapy.
did I move to strike?
So stricken. Listen to the call of the question, sir.
The question is, would you be surprised to learn that Mr. Ponzo on many occasions has stated that he was not doing individual counseling with you?
Yes, because we spoke all the time about.
So I'm not
variety of
asking
things.
about speaking to Mr. Ponzo, I'm asking about him providing individual therapy to you.
He was ordered to do therapeutic
So sir,
reunification.
I'm not asking what he was ordered to do, I'm only asking about individual counseling. Would you be surprised to learn that Mr. Ponzo on many occasions had stated that he is not doing individual counseling to you, with you?
No, because we did sessions with the kids. They weren't individual one-on-ones, they were
Okay,
sessions
so
with the kids.
I just want to make sure I understand your testimony. You initially testified that you were doing individual counseling with Mr. Ponzo. So are you now stating that you were not, that you lied when you said you were doing individual counseling, but it was family counseling that you were doing?
Individual counseling with the children present as a
So,
rehabilitative.
sir, do you understand what individual counseling means?
Well, you're making it sound like it can't be with children
You
present
have to
in a
answer the
family
question,
setting.
sir. The question is, do you understand what individual counseling means? Yes or no, sir?
I'm uncertain.
Okay, what do you believe individual counseling means?
Where you speak to the therapist about your problems.
And is it one-on-one? Is it in a group setting? What is your understanding of individual counseling?
It could be both. It could be with your kids present, not with a group. Group therapy is different. If group therapy with a group of strangers, that's different than having a therapeutic session with a private therapist with your children present. When we're with the children talking about, a variety of family-related items and, their stresses, their joys, that feels
So
like
what,
a individual
starting that,
therapy.
I'm going to ask you a different question. What does the word individual mean to you? Does that encompass more than one person?
It can in a family-related therapy
So,
session.
no, just the word individual. Does that mean one person or does that mean more than one person?
Well, it doesn't mean multiple adults, I would
Sir,
think.
so very specific question. Does individual mean one person or more than one person?
very odd question. I'm
To
not sure.
answer the question, does it individual mean one person or more than one person? You have two choices.
I think one adult present is how I would quantify that.
Okay. So when you say that you did individual counseling with Mr. Ponzo, is that you and him?
We only did the court-ordered therapeutic rehabilitation with the kids. We
Okay.
also did many one-on-one conversations on the phone and in person before and after the sessions. So we would have sessions with the kids and we would have a lot of one-on-one time as well. So I spent a lot of time with him. It wasn't just, and that was the court order. There was no court
sir,
order for.
my question is therapy, not if you had conversations. We're having a conversation right now. Would you consider this therapy?
This is therapeutic in a way.
Okay, so any conversation you have with any individual, you consider that to be therapeutic?
No, but addressing a long history of trauma and going over different, very personal details that mean a lot to you, I believe, yes, this entire proceeding could be a healing exercise and therapeutic in a way, even if it is a conversation with you. I think rehashing all of this is very.
Okay, so you named another therapist you saw in January of 2025. What was his name?
Samuel Hickson.
Okay, and when did you see him, beginning and ending?
We stopped March 5th at the hearing. That's when the new order for Ponzo came in. I've also been doing therapy
So,
with
sir,
Kurt
I
Williams.
would only focusing on Sam Hickson. You said you saw him from January 2025 to March 5th, 2025. Is that correct?
Yes,
And how often did you see him?
once a week.
And what did you address with him?
He was concerned about the inconclusive
No.
pre-diagnostic.
Sir, I'm only asking you, what did you address in your counseling sessions with him?
Everything. Family life,
Is there-
personal life.
Did you learn anything from those sessions?
Yes.
What did you learn?
And it's a lot. How to improve your mindset regardless of the circumstances that you're facing. How to communicate better with, how to, think independently and constructively and efficiently. Just a lot of self-improvement, personal, reconstructive sort of exercises, I guess. I guess that would be kind of a summary of
Okay.
many different things we talked about.
You said you learned how to communicate with. True that you had an extended protective order against you that prevented any communication with.
Yes, but it was due to expire, and
So you answered my
Alright.
question.
we were
You answered my question.
mostly addressing the past
So hold on, sir,
communication issues.
there's no question pending.
Okay.
Are you seeking to strike that, counsel?
Yes, Judge.
Okay, so stricken.
And you mentioned a third therapist that you saw. Who was that?
Kurt Williams.
Can you say the name again, sir?
Kurt Williams.
Thank you.
And when did you see Mr. Williams?
Started seeing Kurt in March 2025, and I'm still seeing him today. Dr. Ponzo was the only court
Sir,
order.
there's no question pending.
Okay.
And what are you addressing in your therapy with Mr. Williams?
Everything in life.
Okay.
Being a father,
And what
being
have
a
you learned?
co-parent.
What have you learned in your therapy with Mr. Williams?
Mostly what I've elaborated on already with the other therapist. He's been just a really good life coach, teacher, great person to talk to. Self-improvement is what we work on. Every element of self-improvement, being a better father, person, preparing to communicate, as a co-parent, preparing to end this process hopefully one day and be liberated from the court system and incarceration, and just very optimistic, healthy topics.
Okay. Did you provide him with a copy of Dr. Leon's evaluation?
Yes.
And is he, what credentials does he have to provide therapy?
I'm not sure. I haven't seen. I'm not sure what's there. I don't know what any of the therapists. If they graduated college or if they have doctorates. Or I know Dr. Wilburn had a PsyD doctorate.
So we're just talking
Right.
about Mr. Williams.
He answered the question, he's not sure.
I'm not sure.
Okay. Do you recall being in front of Judge McConnell at a return status check and advising her that you were not in therapy because you thought that once Dr. Ponzo was ordered that you did not have to do individual therapy?
We were not subpoenaed for any therapy. The only active mandatory therapy was the therapeutic visits. I didn't bring therapy notes.
My question was, do you recall being in front of Judge McConnell and telling her that,
I don't
on the
remember.
record, let me finish my question. Do you recall being in front of her and telling her that you stopped doing individual counseling because you thought after therapeutic visits were ordered with Dr. Ponzo, with Mr. Ponzo, that you did not have to do the individual counseling?
I stopped with Hickson and
No,
St.
no.
Parents.
So my
Yes or no
question was, do you recall saying that to,
I don't
Judge
remember.
Do you have the date of that hearing, counsel?
yes, I'm just looking that up. It was a return status check. At any time, did you tell the court or my office that you were doing therapy with Kurt Williams?
I believe I called, or I tried, I don't remember.
Okay. And how do you currently do therapy with Dr. Williams? Or not Dr.
He's
Williams,
not a
Mr.
doctor.
Williams.
We do phone calls.
And how often do you do phone calls with him?
2, 3, 4 times, or sometimes we talk every day, but at least weekly.
Is that a service that you pay for, or is that something that's done through the prison?
I call him through the prison.
No, is that something that the prison provides, or is that something you do on your own?
Been doing it on my own. I started talking to him before I was incarcerated, and I've been talking to him through the entire incarceration.
And where does he work at?
I believe he's retired.
So does he have a current practice or
I'm not sure.
that you go through? How did you come in contact with Mr. Williams?
I met him through a friend at a house I was renting.
Okay, and how did you come to find that he provides therapy services?
through bumping into him and talking to him about it.
Okay, so to your knowledge, does he have the credentials to provide therapy?
I'm not sure what credentials he has, but he's a counselor.
And how do you know that?
He told me.
Okay. Do you have, when you were at Liberty, did you go to an office to do sessions with him, or how did that come about?
I do him on the phone.
Since the beginning?
Yes.
So you've never gone to an office and met with him? Is that correct?
No.
So you have?
No, I've never been to an office of his. Most of the counselors that I would see who do telehealth, or you find them online, do virtual Zoom calls or phone calls. Everything is virtual these days, except for the in-visit sessions with Dr. Ponzo, because I see the kids there at his office or at the park.
And Judge, the court date was June
17th.
17, 2025.
Thank you.
When was the last time that you had contact with your children?
June 27th last year.
When was the last time you, or was that supervised or unsupervised contact on June 27th?
Is it a therapeutic solution?
So was that a supervised visit?
Yes.
When was the last time you had unsupervised contact with your children?
August 8th, 2024.
And tell me, how did your contact went from unsupervised to supervised?
Judge Tootin did not procedurally address the chronological order of contempt that took place between then me, and he suspended my visits because I couldn't file a motion to hold her in contempt after she violated an order to take a 19-day vacation instead of a 14-day vacation. Judge Henderson had me on the heightened scrutiny standard, which disallowed me from filing motions for 6 months prior to that, or for a year prior to that. I did the order 20 different times between November 2023 and July 19th, 2025. Anytime I filed a motion to hold her in contempt, the heightened scrutiny standard automatically rejected it. Between June 30th and July 19th, 2024, opted to take a 19-day vacation per your advice that she was allowed to, when she took a 14-day vacation in 2021, 2022, and 2023. We were both separate from the kids for 14 days only. In 2024, she decided, with your counsel, that she could just take 19 days against my permission, and after the 19th day, she dropped the kids off, and I told her I also wanted to take 19 days to match her 19 days, and on the 14th day of my 19 days, you filed a motion to put me on monitored visitation, There was a judge shakeup coincidentally that week. Judge Tootin, who had no experience with the case, granted your motion and then granted the suspended visits and put me on trial less than 14 days after your motion, which to the best of my knowledge is procedurally illegal in Nevada. He then suspended my visits and said that he would also impose equal sanctions on if she had committed contempt, and that he would host a contempt trial for her as well, and he would also alter child support. He did not grant my contempt motion. He did not grant the child support motion. I filed a motion to disqualify him. That was granted. The case was transferred to Judge McConnell, and she did not alter the custody order that the disqualified judge made. My visits were suspended after the first week of November 2023. My son's birthday, his 8th birthday, 2023. I'm sure you're both familiar with her withholding the children from Christmas Day 2023 to January 18th, 2024. And then she also withheld the children from June 30th to July 19th. In total, that was 6 different events of contempt. And I attempted to match just the 19-day vacation after all those violations. I attempted to match the 19-day vacation, and on the 14th day, when I didn't return the kids, within 4 hours of the return time, there was a motion to disqualify, or a motion to suspend my visits, and Judge Tootin, who had no history with the case, granted it and ordered a contempt trial less than 14 days after that motion was granted. I did not have an attorney. I was not prepared for the hearing. I believe my civil rights were violated. I filed a motion to disqualify Judge Tootin, and it was successful.
Okay, so I'm going to stop you there. And
Sure.
all of that, did not hear is there anything that you did that resulted in you getting supervised visits?
I had the children for a few extra days past the time we agreed to meet up. I took 14 days, and I took 14 days intending to take 19, and on the 14th day, I was informed that you're filing for supervised visitation, that even if I return the kids, I'm not gonna see them for however long till the next court date, because you've actively decided that you're gonna take 30, 40 days, regardless of if it's the correct thing to do or not. And I was scared to return the children immediately, so I waited for the hearing to return the kids. It was on the 19th day, coincidentally, on my 19th day, which also matched 19-day vacation. On my 19th day, we had the hearing in front of Judge Tootin, and he suspended my visits and scheduled a contempt trial. I don't think I did much wrong. I just tried to match the vacation time that you were both familiar.
So, okay, let me ask you this. Did you file a motion before the court to take extra time, to get permission to take extra time?
Yes, I tried, and it was
No,
not.
so, okay, what date did you file the motion?
Sometime between August 2nd and August 15th, I filed the contempt motion and
What year?
the order for custody, and Judge Tootin said that he was going to grant it and impose equal sanctions, which he did not do.
The question was, when you withheld the children, did you file a motion with the court to get permission to withhold the children? It's a yes or no question.
I made you and that I
So,
was going
sir,
to
did
match.
you file a motion with the court to get permission to keep the children extra days?
So yes or no?
I'm
question,
pretty
yes
sure
or
I
no?
did.
Okay.
I tried to, and it was rejected by the heightened scrutiny standard, because that's what
I
Judge
just need a yes or no answer.
Henderson put on there.
I'm pretty sure I did as a yes, okay.
And what time period was that? that you would have filed a motion?
Between August 1st and August 15th, or July 20th and August 15th?
So Judge, I would request that you take judicial notice that no motion was filed by Mr. Cristos during that time period.
Okay. The court will also take judicial notice. I have to look at that.
Yes.
It was in the contempt
I'll check the
motion.
file. There's no question pending, sir.
Was it?
There's no question pending.
And is that correct that once, that Judge Tootin granted you an evidentiary hearing?
He did not, he didn't grant them, he said on record at the evidentiary hearing that he was
So,
going to
sir,
grant my motion and impose
Is
equal
it
sanctions.
true that before you were held in contempt and the psychological evaluation was ordered, that the Judge Tootin held an evidentiary hearing? Where just like what we're having today, where testimony was taken.
Yes, I believe it was August 15th. There was a 40-minute hearing that didn't go over all of the details of why.
So, sir, were you given time to present your defense in that case?
No, not adequate time, no. I mean, he
Did
scheduled,
you ask Judge Tootin for more time to be able to complete the evidentiary hearing?
I believe so. He scheduled an evidentiary hearing 7 days from the motion hearing. He scheduled the evidentiary hearing 13 days from the time you filed the motion. It was, I had
So, sir, the
8
question
business
The
days.
was,
question is, where did you ask for more time to present your case, sir?
I might have, I think so, I don't remember. I remember thinking this is
Okay.
such a spoofy misunderstanding, surely he'll just hear a few
Are
sentences
you
and
moving
say,
to
oh,
strike
that
that?
checks out.
yes, Judge, and I would request that you take judicial notice of that hearing, that no such request was made by Mr. Cristos to extend the hearing.
Okay. The court will also strike the among the points of testimony and take judicial notice of, what was the date of the hearing?
This is
August 15th,
August
2024.
Thank you. August 15, 2024. Evidentiary hearing.
How long
I
until
would
we
like
get
us to start wrapping up, Ms. Grigsby, so that we can break and take a break for lunch.
mind reader? Hey, Beth.
Judge, I can recess. We can
Okay.
recess now.
All right, I'm going to stop your time in a second.
So in my line of questions,
1 second, hold on.
oh, excuse me, sorry.
All right, so 31, but I'm gonna minus, there's a lot of time, 68 plus 31 on Ms. Grigsby's time, however, there's several disruptions that were to the time, 2, 3, 4, 5, 6 minutes that were taken away from that would be allocated back to you, counsel. And taken away from Mr. Cristos' time that he used to disrupt your cross-examination. Okay, all right, we will reconvene in an hour. It's 11:57 right now. We'll come back at 1:15, so an hour and 15 minutes, okay?